Good evening, councillors, members of the public. Apologies for the technical delay there. Welcome to this first Eastern Area Planning Committee of this council year. I will move very quickly on to the first item of the agenda, if that's okay, which is to confirm the appointment of Councillor Richard Cole as Chairman of the Eastern Area Planning Committee for the council year 2019-20. Is that agreed? Thank you. I'll move straight on to item 2, if that's okay, which is to confirm the appointment of Councillor David Else as Vice Chairman of the Eastern Area Planning Committee for the council year 2019-20. Is that agreed? Agreed. Thank you.
Thank you for your confidence, councillors. Councillor Cole is currently on a walk-in holiday, which was arranged a long time ago. He's traipsing over Scotland, I think, at the moment. So I hope it's not as muggy up there as it is here, and I hope the midges aren't biting him too much. Right, so good evening, councillors and members of the public. Before we commence the meeting, I'd like to draw your attention to the fire regulations, which are on the screen behind me and the screen facing the public gallery. Can everybody please ensure that mobile phones are switched to silent, and councillors, if you can speak directly into the microphone and make sure your name cards are pushed into the consoles. Right, to move on to the main items of business. Oh, sorry, gentlemen, as it is rather warm, if you'd like to remove your jackets, feel free to do so. And ladies, if you're wearing them. So, right, so appointment of chairman, we've done that. Minutes of the meeting held on the 10th of April 2019 have been on the table for the last 30 minutes. Are you happy for me to sign them as a true record? Thank you very much. Amy, any apologies for absence?
Thank you, Chairman. Apologies from Councillor Cole, the Chairman, and also Councillor Michael Goodridge.
Thank you. Any declarations of interest?
Thank you, Chairman. I believe Councillor Denis would like to make a declaration.
Councillor Denis.
Thank you, Chair. I am declaring a non-pecuniary interest in item A1, as I'm the Chairman of the Allfold Sports and Social Club, which is based at the recreation ground that backs onto the application site. The club has no view on this planning application and has not made any representations to Waverley on it. Therefore, I do not feel that this interest has sufficient weight to prevent me from taking part in the decision-making on the planning application in my capacity as ward councillor and member of the Eastern Area Planning Committee. Thank you, Chair.
Thank you. Amy, any questions by members of the public or from members?
Thank you, Chairman. None received.
Beth, do we have any relevant updates to government guidance or legislation since our last meeting?
Thank you, Chairman. None relevant to the matters before members this evening.
Thank you. So just to note that in the event of site inspections being necessary as a result of consideration of the applications at this meeting, these will be held on Tuesday, the 6th of August 2019 at a time to be agreed at the meeting. And so we move on to the main items for consideration this evening. And the first is item A1, our reference WA/2019/0575, land at plot 1 adjacent Byway Cottage, Dunsfold Road, Allfold, and I believe that Alex is going to present the application.
Thank you, Chairman. Just before we begin, ownership with regard to the provision of adequate visibility displays at the site. There is a slight variation to the offer's recommendation, which is as follows. So recommendation A, that subject to the applicant entering into an appropriate legal agreement within 6 months of the date of the committee resolution to grant planning permission to secure the provision of visibility zones as required by the County Highway Authority, part of which fall outside of the application site, permission be granted. And recommendation B, that in the event that the requirements of recommendation A are not met, permission be refused. There's the aircon on. So this slide shows the location plan for this application. The site is located on the southwestern side of Dunsfold Road in Allfold, measuring 0.045 hectares, as edged in red on the screen behind me. This shows an aerial photograph of the site. Members will see that it is currently an unused area of land associated with the adjacent dwellings to the north west. Alford Recreation Ground lies directly to the south. These site photographs are taken from Dunsfold Road in front of the application site. For the benefit of the members who are unable to make the committee site visit yesterday, the area of hedgerow that you can see there has subsequently been removed, and a replacement hedge is proposed as part of this application, which is measuring 0.6 metres in height. And these photos show the interior of the site, including in the bottom right-hand photograph, the existing access to the site. The hedge at the rear of the site, as you can see in both photographs, for the benefit of those who didn't make the visit yesterday, this has also been cut back to the boundary and is proposed for continual maintenance to keep that trim back to the boundary. And these photographs show the rear of the site when viewed from the Alford Recreation Ground. So this slide shows the front elevation of the proposed dwelling. So that with a ridge height of 7.55 metres and a width of 12.15 metres. And this is a comparison with the previously refused scheme on the same site, which was for a pair of semi-detached dwellings. The new dwelling would be 0.3 metres taller at the ridge height, but does have a width, an overall width of 4.85 metres less than the previously refused scheme. These are the proposed side elevations with a depth of 7.9 metres. And again, a comparison with the previously refused scheme on the site. The proposed dwelling under this application is 0.6 metres shallower than what was previously assessed. And this shows the rear elevation. And again, with a comparison of the previous scheme. This are the proposed ground floor plans for the application. And the proposed first floor plans. So you can see it's a 4-bedroom dwelling. And overall, this property does exceed the housing standards, but one bedroom, being the one with one of the ensuite bedrooms, does fall short of the individual requirements for a bedroom by 0.2 metres squared. However, it does benefit, as we said, from an ensuite bathroom. So this is a proposed site plan with 2 parking spaces shown in the bottom right-hand side of the bottom right-hand corner, of the site. An amenity area of 285 square metres is proposed, which is considered to be acceptable by the officers. The previous scheme outline of the site you can see here on the dashed line for the benefit of comparison. And this is a proposed street scene. I appreciate these images are slightly smaller, but again, the outline of the previous scheme in the dashed line there can be seen. So the matters of consideration for members are the planning history and the differences between this and the previous proposal, the design and impact on visual amenity, the impact on the countryside beyond the greenbelt, the impact on residential amenity, on parking and highway safety, and trees and ancient woodland. Thank you, Chair.
Thank you, Alex. This application is subject to public speaking, and I would invite Penny Main from Alfold Parish Council to address the members, please. Good evening. I understand the procedure has been explained to you, and you have 4 minutes from when you start speaking. Thank you.
Okay. Okay. So, As you will have seen from the site visit, the proposed house would be built extremely close to an ancient hedgerow that belongs to the parish council. When the developer built the previous two houses, he ripped out that part of the hedge that ran along the rear boundary of those two houses. Unfortunately, Waverley Planning Enforcement were unable to act as the hedge did not form part of the application site, despite the landscape scheme having shown the hedge to be retained, as on the plan for this application. Therefore, if you are minded to approve this application, Orfold Parish Council requests some form of protection to ensure that the developer may not remove or damage our remaining hedge. When the original application for the two houses already built was made, Orfold Parish Council did not object, but requested that the land now subject in this application be included within the residential curtilage of Plot 1. This was contained in Condition 11 of that planning permission. Condition 11 states, the land to the east of Cottage 1 shall form an integral part of the garden area of Cottage 1 as amenity land. Reason, in order to ensure that the character and amenity of the area is maintained and to accord with policies D1 and D4 of the Waverley Borough Local Plan 2002, and these are still retained policies. Policy D1 seeks to promote and encourage enhancement of the environment, the relevant part being development will not be permitted where it would result in material detriment to the environment by virtue of harm to the visual character and distinctiveness of a locality, particularly in respect of the design and scale of the development and its relationship to its surroundings. Policy D4 states that the Council will seek to ensure that development is of a high-quality design which integrates well with the site and complements its surroundings. In particular, development should A, be appropriate to the site in terms of its scale, height, form and appearance. Both these policies are relevant to this application. Condition 11 sought to maintain a reasonable sized garden for Cottage 1, but the policies also support our objection on the grounds that this is a very large house on a very small plot, very close to the road, which is totally out of character for the village of Orfold. As you will have seen on your site visit, the gardens in Orfold have traditionally been quite large and certainly much larger than those provided with these new houses. Finally, the NPPF states that a planning decision should support development that makes efficient use of the land, taking into account the desirability of maintaining an area's prevailing character and setting, including residential gardens. The proposed development does not maintain the prevailing character of this rural setting. The development would make no contribution to the village as required by the NPPF. Thank you.
Thank you. Members, Councillor Denis.
Thank you, Chair. Thank you, members who attended either the last site visit or the one before, and probably the one before that as well. A lot of what I was going to start off with, Councillor Main's already actually just mentioned, it's looking at the previous application in 2015, two houses with reasonable sized gardens. The condition that Councillor just read out was to ensure the character and amenity of the area is maintained. And that was policies D1 and D4 has been mentioned. These are retained policies. These are conditions that Waverley set. So Waverley felt that they were necessary, Waverley set them. And as they are retained policies, they carry full weight. So we then went to the application 2018, which was the two semi-detached houses, which we went and viewed. And again, it was decided that non-compliance with policies TD1, D1 and D4 were the grounds for refusal. So my question is, what's changed with this application? In fact, what has changed over the two applications? It's been mentioned about condition 10. They will have to deal with that if it is approved. So tonight's application is for a huge 4-bedroom, 2-bathroom house, which has got 3 toilets, parking for 2 vehicles, turning space, bin storage, bike shed and a garden. And I'm sure you're all wondering, who've seen that site, How are you going to fit that all in? It's been mentioned about the property being located close to the boundary hedge. If you look at the rear boundary hedge, I think it's probably about 20 foot. I haven't measured it, but I would guess it's about 20 foot. So if you look down from the back of that house, you will see a wall of hedge and tree of 20 foot right behind you. At the front, it is close to the road. That is totally out of character. If you go down Dunsfold Road, they are all spread much further back from the road. It looks out of character. On page 15, if I can just turn members to page 15, please. The officer states that planning history is a material consideration. Well, I think the planning history speaks for itself. This is countryside beyond the green belt. This is outside the defined settlement area. And policy RE1 states the intrinsic character and beauty of the countryside will be recognised and safeguarded in accordance with the NPPF. So how does a back garden infield development achieve this? Page 16 states that the hedgerow will be planted following agreement with Waverley. So I don't think they've got an agreement, they've just butchered it and chopped it all down to make the plot look bigger. And then they've got to plant a new hedge. Now, Highways originally objected to this, but they did a U-turn, saying this could be achieved with a condition. Well, you certainly couldn't do a U-turn in that location. If you look at the diagram, which is up there, where it's got the vehicles, and if you look at the car on the right-hand side coming out onto the road, well, just imagine where the driver would sit, which is a lot further down that vehicle. That car would be pushing right out into the main road to get a really good view. There's a great lot of detail about distances to the neighbours, about the houses opposite and etc. But the houses opposite have views from their upstairs towards the recreation ground. It is a shame they may longer be able to have and enjoy this. Although the report states it's not a material consideration, we should remember the impact developments have on others. Page 18 then says, with a small section of hedgerow removal to facilitate. So again, they've contradicted because they've chopped it all down. Page 18 says they're going to remove a small amount. The whole length of the site has been chopped out, and I hope the developer considered the wildlife and birds removing the front hedge and cutting that rear hedge, especially at time of nesting. I'll just quickly talk about the design and access statement.
Councillor Deaners, can you sum up? As ward councillor, I will allow you to come back at the end of the discussion, but thank you.
Okay. I'll just make one other point and I'll come back then if I may. Of the design and access statement, point 2.3 states, the detached house previously consented does not require so much amenity space, which is disproportionate to the size of the dwelling and is unviable as it's so distant from the main house. What an absolute ridiculous statement of the developer to make. It's within touching distance. Thank you, Chair.
Thank you. Members, anybody else have comments to make? Councillor Townsend.
Thank you, Chairman. Perhaps I could just go back to what the officer said in the opening, the update, the verbal update initially. Could you just please clarify, looking at the red line boundary of the site, is that no longer the red line boundary now? Is there some issue over the front boundary? If I may come back after that, thank you.
Thank you, Chair. Yes, Councillor Townsend. So no, the red line site is still the red line site, but it's as part of the blue line site, which demonstrates ownership of the wider ownership of the applicant. So there's a visibility display line which goes through that land. So that was to make sure that has remained clear. We need to make sure that in perpetuity that is kept clear for the visibility displays. Does that answer the question?
Okay, thank you. So I've got a couple of things. One of the things is about the visibility space. I mean, I'm very aware of that road and the way the traffic does come very quickly down there. And also whether or not the cumulative impact of the amount of traffic that goes down into use that road now for the increased industrial area of Dunsfold, and also with the Gordon Murray HQ going in there as well. I mean, I think the traffic is only going to increase on that road, and I cannot see how a condition has been put on, which is page 23, which, to be honest, I cannot see how anyone is going to police the fact that we're going to keep permanently clear of any obstruction over 1 metre high. I think that's a completely ridiculous and impossible condition to actually put on this, that we're going to be policing in perpetuity for someone, if they're growing a hedge there, because they say it's going to be a replacement hedge, for that to be kept permanently clear of any obstruction over 1 metre high. So I do think that is a big concern, considering the speed. And as Councillor Dean has said, you have to put the nose of the car quite far out before you would be able to actually see. One of the other things that I picked up, which I did speak to you earlier about, was the fact that Thames Water, within their email, against the application, said that we should seek approval from the lead local flood authority. And I'm aware usually on an actual development of this size, we wouldn't normally need to contact Surrey. However, Thames Water has specifically requested that we should seek approval, and also have pointed out in their email about the historical incidents of hydraulic flooding. And I know for a fact, that there is a constant flooding issue here with sewage, and the sewage being overwhelmed in times of reasonable and heavy rainfall. So I have got that concern as well on there. One other thing I just wondered if you could just clarify was, how big is the actual garden, as in what is the length of the garden from the house? Could you just clarify that if possible?
The site plan shows it as over 15 metres from the side wall of the family room to the fence with the substation.
Thank you, Chairman. And my last point is really with regards to the condition and the weight to give the condition. I mean, I feel slightly, very much in agreement with Councillor Dinas to say that we put the condition on there because it was considered reasonable at the time. The applicant had the opportunity to challenge that decision at the time and say if it was unreasonable. They obviously thought it was okay and reasonable. So we've got the condition that this should be what's called an amenity area, I think was mentioned. An integral part of number 1 byways and an amenity land. So what weight can we give that condition in considering this application? Thank you.
Alex, would you like to address those questions? Beth, sorry.
Thank you, Chairman. Thank you, Councillor Townsend. In relation to that particular condition, I mean, clearly it was desirable to impose that condition at that time. This application has come before you. It needs to be considered afresh. In many ways, that condition is, by the by, should planning permission be granted tonight, this marks the start of a new planning chapter. So you need to be satisfied that if you are minded to grant permission, that the amenity space is sufficient. I personally would advise you set aside the condition as was previously imposed as a separate issue, ensure that you are satisfied in terms of amenity, that is sufficient. If I could go back, if I could go back to the question regarding the 1 metre height hedge and policing it. Believe it or not, I mean, these are quite common conditions, and with my enforcement hat on, fairly commonly investigated in terms of people not being able to see out of junctions. I appreciate this is slightly different in that it is a private house onto a main road. As with any condition, construction hours, anything like road sweeping, we rely on the public bringing those to our attention, and I am confident that if it was such a cause for concern, then it would be raised with us as the enforcing authority. The condition would be thrown up on any search by a land agent, and any restrictive conditions would be thrown up on that as well. So any occupants would be aware of that responsibility. Anyone passing by with an awareness of that permission would also be perfectly at liberty to say, I have a concern about traffic coming from the site. Thank you, Chairman.
Could I just come back on that slightly, Chairman? But I appreciate what you're saying. You're saying that the condition is there and would be enforced. Well, throwing it back on you then, so why isn't the other condition then, you know, is as relevant as the 1 metre and keeping it low, and we would enforce it, and that. So therefore, surely the other condition should be enforced and equally they stand as conditions against the original planning application.
Thank you, Chairman. Thank you, Councillor Townsend. I think what would have to happen if I think Beth is right to say that you have to look at this application afresh, in the sense that you have to review what is being proposed and determine whether or not its impact is negatively affecting the amenity of neighbouring properties or the area or not. For instance, if you were minded to grant permission tonight, the consequence would be that the existing permission, which has the existing condition attached to it, would potentially be breached, or at least when the development is commenced. We would have to consider whether or not enforcement action would be necessary at that point in time, although I suspect, as I say, if permission was granted tonight and development did commence, that we would consider it wouldn't be expedient to enforce that condition, because you, the committee, have subsequently found the amenity to be acceptable for this application. However, I don't think that you can necessarily rely on the existing condition necessarily as a reason to refuse permission this evening. I do think it's important you reassess the impact on amenity in accordance with what's before you tonight. I hope that's somewhat satisfactory. I appreciate that it's not necessarily the cleanest approach, but I think that's probably how it would have to work out in a practical sense. Just one other thing on the condition relating to the visibility display. My understanding, a condition was recommended by the Highway Authority. As you've heard tonight from Alex in the update, we now think it's necessary to include similar provisions in a Section 106 agreement, because we are dealing with third-party land. So there will be kind of a more robust Section 106 planning obligation put in place to ensure that that visibility display, as required by the Highway Authority, is maintained in accordance with the relevant specification. So I appreciate what you say about the enforcement issues, but we will have a greater means of enforcing any non-compliance with that obligation, because we can enforce it through the High Court as opposed to normal enforcement powers. Thank you, Chairman.
Thank you. So just for clarification, if the committee were to grant permission for this application tonight, they would be granting permission in breach of a condition of a previous permission. Is that correct? Did I understand you correct?
Thank you, Chairman. My view is that I think Beth is right in saying that there will be a fresh start in terms of planning history for this area of land that we're looking at tonight. But there will be a planning unit which has the existing dwelling on it, which benefits from a permission that has a condition attached to it that that sought to ensure that this area of land was protected for amenity values. I do think the consequence would be that they would potentially, if this permission was commenced, would be in breach of that condition, but that would become a separate issue that we would have to look at then and there.
So the ideal scenario would be that if permission were granted, they apply for an amendment to their existing permission to have that condition removed.
That would
Does that make sense?
That would certainly be one option open to them, yes.
I would think it'd be the only option, otherwise they'd never be able to sell the house because it hasn't complied with the planning condition. Anyway, that's, before we move on, and I know a couple of others want to speak, regarding the visibility displays, I mean, our condition 8 here says any obstruction over 1 metre high. The drawing actually says over 0.6 of a metre. Alex in his report said 0.6 of a metre, and in my experience, highways have always asked for 0.6 of a metre. I'm just thinking of Councillor Henry in her sports car trying to get out. I think a metre high hedge she might have, and I'm not being heightist, I'm thinking of the height of your car rather than the height of the driver. So I think that possibly, if nothing else, condition 8 should be changed to 600. I'll move on. Councillor Seaborn.
Sorry, I didn't get any answer to the lead local flood authority question about Thames Water.
Apologies.
Thank you. Sorry, Chairman, to interrupt.
Sorry, in answer to your question, you're right, generally we wouldn't consult them on a development of this size. It's only 2 units, it's normally only 10 or more that we would consult them. If members felt that that would be appropriate, we could write to them separately or put an informative on the planning permission to make them aware of the proposal.
Okay, Councillor Seaborn.
Thank you, Chairman. Well, I'm in complete support of all the comments that have been made about the condition from the 2014 application. I just find it, we've established that at some stage the condition has to be removed if this can go ahead legally. Surely that should be the starting point, followed by this application rather than the other way around. However, I mean, the point I would like to make relates to the paragraph on parking. It says the council's parking guidelines set out a recommendation of 2.5 spaces. Well, we all know 2.5 spaces is a nonsense for a single property. It works fine when you've got shared parking on a multiple site application. So then you have to look at where you are. You're in a rural setting, 4-bedroom house, with a likely outcome at some stage during its usage of probably 3 cars. You'll end up with 1 car more than the available spaces. And then there's going to be the temptation to tootle round the corner to the village hall, which has parking specifically assigned only for use of people using the village hall. So that there's a potential abuse of an available solution there. It seems to me that there is space on this side to accommodate a 3rd parking space, and a bit more of the garden space should be sacrificed. But if we were minded to approve this, I totally disagree with officer's consideration that 2 spaces are adequate, I think we should be looking at a condition of 3 spaces, because that's a very likely demand, and there just isn't suitable alternative spaces off-site for people to use. So if I could leave that with you. Thank you.
Thank you. It was a point I was going to raise, so I'm in complete agreement. Councillor Gray.
Thank you, Chairman. I do agree with the comments that have been made before, and in the interest of brevity, I won't repeat them all. I'm sure that delights you. I'm going back to the previous application which created the adjacent properties, 2 of them. That was, I believe, in the same ownership. Is that correct? Yes. So effectively, he's either sold that house without the amenity land, or else he's intending to sell it. I don't think it's sold at the moment, but he's intending to sell it without the amenity. And to me, we've granted that permission, we've got a condition on it, and his first action should be go through and seek for that condition to be removed, not to put in a new planning application for you to grant effectively an amnesty, right? It's what it sounds like to me, is if we go ahead with this, all sins are forgotten, and basically he can continue. To me, he should be applying for that condition to basically be removed, and we should hear that in isolation. We as a council and the committee agreed that application on the basis of that condition. That's my first point. If you allow me to go on, there's one other point, is how do we take account of what the concerns from the parish council, which was the hedge. I think before you said they couldn't do anything about it because it wasn't in the property. But you know about it, there must be something we can do to make sure that that hedge is protected. You're doing something in the section 106 for the hedge at the front. I would suggest we need to do something about the hedge at the back in a similar sort of way. Thank you, Mr. Chairman.
Officers, any comment on Councillor Gray's concerns?
Thank you, Chairman. Just in relation to your point about the order of how things should proceed, I think it's just useful to clarify what I was saying earlier. Maybe I'll try and put it a bit more succinctly. But my view is that the condition, or the existence of the condition, doesn't preclude you from granting permission tonight. However, you may still rely on the same reasons relating to amenity that led you or the previous committee or officers to impose that condition originally to refuse this scheme as well. So you're not precluded either from relying on those same amenity reasons to refuse permission, but equally if you don't share those reasons and you think actually this is acceptable in amenity terms, you're not precluded from granting permission. The only result of granting permission would be to cause that other development to be potentially to be in breach of its condition. It wouldn't stop this development from going forward. It would be an issue for the other development to rectify. As I say, I think if we got to that point, it would be fairly technical, because you will have acknowledged that the amenity issues can be overcome, and it may well be resolved either by deciding it's not expedient to enforce or through a Section 73 or Section 73A application. But I hope that clears things up somewhat. Thank you.
Councillor Gray, you wish to come back?
Okay, using your own words, so therefore it's a technical breach he's committing, because effectively by putting this application in, he's breaching his conditions on 10. And you as Waverley councillor should actually acknowledge that. It came first. That application, that condition, the same owner, the same thing is now putting an application, knowing that he was bound by a condition before. And I find it very strange that someone can ignore, and I mean, this is a relatively minor case, but an important one. But if you've got a large estate with lots of conditions, basically they can go and take an adjacent piece of land, put in an application with all the conditions associated with, and we can look at it totally fresh. I find that astonishing.
Did you wish to come back?
Only very briefly.
I know Beth wants to speak as well. So.
Just to say, I would just highlight that there would only be a breach of the condition at the point at which the amenity land is used for some other purpose. Granting permission tonight wouldn't automatically mean they are in breach of that. Simply by applying for this permission doesn't mean that they are in breach of that condition. They would have to actually commence the development and actually start using that land for some other purpose, although I appreciate your concerns.
Thank you. Councillor Woroszewski.
Thank you, Chairman. I think Councillor Gray's point was very well made, and I think the whole scenario here with regarding the conditions is really messy. Anybody watching this on webcam, I think, would find it hard to understand exactly what's going on here this evening, because I do, and I'm a part of this committee, and I've been in the part of this committee for a long time, but I'm completely confused as to how we've ended up in this position. But I would remind members that on page 15, where they talk about planning considerations, the history differences of previous proposals, etc. The test tonight is whether, having regard to the changes, the current proposal has overcome the objections to the previously refused scheme of 2018. And I think that's what we should be looking at in this situation and circumstance tonight, bearing in mind the amenity space, the condition, and going forward. So, yes, what a mess, but never mind, we've got to get through it. Thank you, Chairman.
Thank you. Anybody else like to speak? Sorry, Councillor Reid.
Thank you very much, Councillor Denis. I come to this freshly, having been just elected as a councillor. So although I've read the planning history, I am looking at it as a new application. There are concerns in what I'm going to say, but going over the points that Ms. Councillor Denis made, not everyone wants or needs or desires a large amenity garden, especially nowadays. I looked at all the conditions and I looked at all the previous comments that were made. I looked at the comments that were coming in from both parish and from members of the public, and I thought that the officers had done a very good job on addressing all those points. And therefore I can't see, and I want to particularly go into some of those and give my reservations on an additional thing. Basically, the front line of building is further back than the two semis that were applied for. Isn't that correct? So that's a plus point. It won't take up as much space. It does fit in with the street scene. The only thing I can see where it might not, in that it is further forward from byways, cottages. Surrey County Council initially said that there was not that much of a problem with the vehicles getting out, but then since you've mentioned that there might be a condition on that. Enhancing the environment, it is between two other houses. No one has a right to a view according to planning policy, and I would think that people looking across the road from the houses opposite will have more of a view with a single house than they will with two. My biggest concern, though, is the hedge, I must admit. I was appalled to see that in the nesting season that half of it had been cut back. That does concern me, and especially I have a concern about any future hedge at the front, which has already been discussed. That's all I want to say at the moment. Thank you.
Thank you, Councillor Reid. Sorry, Beth, you wish to make a point?
Thank you, Chairman. I think the subject of the sequence of the applications has come up. To a large extent, whilst I completely understand your concerns, the sequence is immaterial insofar as previously mentioned by Lewis, there would be no breach until any planning permission were implemented. So it's really up to the applicant or another as to what they would like to come first. Turning to Councillor Gray's point, should the permission be implemented in breach? It is a technical breach, and it is, as members will know, it is not fait accompli just because a breach exists. There is automatic harm. Harm has to be established for action to be taken. So that would be for the Waverley as local planning authority and the enforcing authority to assess should that arise, although I hope from these discussions that the applicant would now be aware of such concerns. Turning to Councillor Forashevsky's point, it's very valid. The previous refusal reason, this application was submitted to overcome that. So implicit in the previous refusal reason is, you know, the fundamentals were considered by the committee as it was then. They were considered to be acceptable. There was this particular element that was considered to cause harm. Reason for refusal was imposed. The submission is here to overcome that, and I would suggest, or I would caution you against adding subsequent reasons on top of this now, because it could very well be deemed unreasonable come an appeal situation. Thank you, Chairman.
Thank you, Beth. Councillor Henry.
Thank you, Chairman. I'd just like to pick up on with regard to the rear boundary, please. I do echo the local parish council's concerns. It is important to maintain that beautiful hedge on the back, which is in the playground. It's young oaks and hawthorn. And it is a good boundary line, and it's important for the playground to have a safe and secure place for the users of the playground to use. So I just wanted to flag that up, because we're those people that know the site and know that the trees on the site of the application have been cut back very severely.
Thank you. I'm just looking again at the parking and the visibility displays, etc. And condition 8 says that where thereafter the visibility zone shall be kept permanently clear of any obstruction over 1 metre high. And now we're looking at a section 106 to enforce that. Looking at the site plan that's on the screen, the visibility display runs through the middle of that car. So that parking space can't be used. So instead of only having 2 spaces instead of 2.5, we've now got 1.5 spaces. So it just seems to me that this hasn't been thought through properly, and these visibility displays have been added on at some later date after the scheme has been considered. I agree with Councillor Reid, there's plenty of room for parking in that area, but as it's drawn, you couldn't park a car there because it would be in breach of the section 106, and therefore the turning manoeuvres that are shown on this drawing are a nonsense, really. So I'm a little bit concerned about granting approval for something that A, will breach something that we came to a decision on before, and secondly, something that can't be actually built as it's shown. So they'll be coming back with more amendments to try and make it work later. I think I'd rather see a scheme that really does work, and I tend to go along with Councillor Gray's point about discharging or removing the condition, or attempting or putting in an application to remove the condition first. But would anybody else like to say anything? I will invite Councillor Dean as Ward Councillor to come back.
Thank you. Planning application for this site shows the site, current use, as residential amenity. But I think we've all seen that's not right. Councillor Gray mentioned about the house being up for sale. It is up for sale. If you look on Google or one of the sites, it actually shows it for sale without that site being part of the garden. So they say it's part of the residential amenity, but the number 1 cottage hasn't got that as part of the land being sold for that first detached. So there's a huge contrary to that. I mean, I'll just summarise. This is overdevelopment of a small area of land which has been designated as a garden. It's out of character, cramped location, and it's out of character for the village and rural setting. And I would say nothing has changed. It's the same small piece of land. And I actually think the grounds from the previous refusal have not been overcome. So without getting into any other issues, just the previous grounds for refusal, I think they are still as valid today as they were when we dealt with it in 2018. Thank you.
Thank you. Councillors, are you happy for me to move to the recommendation? Alex, as I haven't got the revised, updated recommendation in writing, and it was rather long, would you like to repeat? Oh, thank you very much. Look at that. Oh, yes. Could we first, before we vote, could we agree that condition 8 should be restricted height to 0.6? Would everybody be happy with that instead of 1 metre? I'll do that by show of hands. Yes, agreed. Thank you. So recommendation A is that subject to the applicant entering into an appropriate legal agreement within 6 months of the date of the committee resolution to grant planning permission to secure the provision of visibility zones as required by the County Highway Authority, part of which fall outside the application site, and there must be more to it than that, and subject to conditions 1 to 7 and 9 and 10 and revised condition 8 and informatives 1 to 10, permission be granted. All those in favour? Sorry, Councillor Townsend.
Chairman, earlier there was some other conditions which were requested, and I think we've mentioned about the car parking spaces. I also asked about the lead local flood authority being consulted, and it was said that that could be conditioned. And I also think that the parish council asked about a condition to protect the hedgerow, and we did sort of moot that as well. So is it possible as well to work towards other conditions as well as just your one? Thank you.
You make me sound selfish, Councillor Townsend. Officers, would you like to address that, please? I think we will need a totally revised recommendation A.
Chair, if I can just come back on that. The point about the lead local flood authority, that could be an informative, not a condition. We could have a additional condition about the parking layout to be submitted and agreed. And apologies, the third, was it the hedge? The hedge at the back. My understanding that's not within the site, so I don't think we could control that. There is a landscaping condition proposed, but that would obviously only be the landscaping within the site that could be controlled.
Well, you say that, Marie, but when on the site visit, we were assured that the applicant considered that the boundary ran through the middle of the hedge.
In which case, the landscaping condition would apply.
Thank you. So what do we have now then? So we have the recommendation, we have conditions 1 to 7, revised 8, condition 10,
11 about parking layout.
11 parking, and additional informatives.
About the flood authority.
We've got a landscaping condition in there already, haven't we? Yeah. Additional informatives regarding the Thames water. So let's try again. So recommendation A is that subject to the applicant entering into an appropriate legal agreement within 6 months of the date of the committee resolution to grant planning permission to secure the provision of visibility zones as required by the County Highway Authority, part of which fall outside the application site, and subject to conditions 1 to 7, revised condition 8, condition 10, new condition 11 regarding parking layout, and additional informative regarding Thames Water. Permission be granted. All those in favour?
That's 1, Chairman.
And against?
That's 10, Chairman.
So that recommendation is refused. Thank you.
Councillor Reid would like to come back.
Councillor Reid, you'd like to come back? Certainly. So, firstly, I need a recommendation to refuse this application and a seconder, please. Okay, thank you. Now, the officers have suggested that in light of members' view that the previous reasons for refusal have not been overcome, they would suggest that the identical reason be cited in this instance. So that reason is that the proposed development, by reason of the shape and size of the plot and siting of the dwelling in close proximity to the road, would result in a cramped and contrived development that would be harmful to the visual amenities of the street scene and the character of the area, contrary to policy TD1 of the Local Plan Part 1 2018 and retained policies D1 and D4 of the Local Plan 2002. So proposed by Councillor Denis and seconded by Councillor Townsend. Are you happy with that reason for refusal? All those in favour of the refusal, please.
That's 10, Chairman.
And those against?
That's 1, Chairman.
Thank you. Would you like that recorded as well, Councillor Reid? Certainly. So we don't need to go to recommendation B, do we? So, right, thank you, councillors. We move on to the second application for consideration this evening, which is item B1, our reference WA/2019/0677, land at Queensway, Cranley, and Jessica. No, Jessica's not here. Alex is going to introduce.
Yes, thank you, Chair. So this application is for the land at Queensway, Cranley, and is, as said, Section 73A to vary Condition 5 of the previous scheme. So the application site comprises 2 grassed areas adjacent to either side of the existing highway, Queensway. And so this application is to vary Condition 5 of the previously approved Waverley Borough Council application to allow for the staged approach to implementing electric vehicle charging point provision. So this is in line with a borough-wide scheme for the implementation of such charging points, together with a national supplier which has been tied into throughout Surrey. So the existing condition, for which the original permission was for parking spaces, the existing condition requires that 2 fast-charge electric vehicle charging point sockets be provided prior to the first, what is said as occupation or use of the spaces. So this amendment to the condition would require the requisite underground cabling and underground infrastructure be put in place prior to the first use of these spaces, but to allow for an additional year to actually put the charging point sockets in themselves. So yes, and that will be so from 1 year of the date of the decision notice to implement the actual sockets themselves, so it can tie in with a wider borough-wide scheme. So that's it in terms of assessment. The matters of consideration are the design and impact on the visual amenity, on residential amenity, and on the highway safety. Thank you very much, Chairman.
Thank you, Alex. Members, any comments? Councillor Henry.
Thank you, Chairman. Really, just a comment. I'm pleased that this has triggered Waverley to develop a borough-wide strategy for electric charging points. Thank you.
Yes, I'm delighted that Waverley's going to put all the infrastructure in, but I wonder whether we would be sympathetic to an individual developer having the same issues. Waverley's got to get its act together. We agreed this, or it was agreed on the basis that charging would go in. I'm wondering whether 12 months is really too long. There should be some impetus to get them in. And what is the problem of putting something in there and then changing the supplier? I'm not technically aware that would be an issue. I'm just disappointed, I think, Chairman, not necessarily objecting it. I'm disappointed that we haven't really got our act together in order to be able to deliver this. Thank you.
Thank you. Councillor Townsend.
Thank you. Just quickly, in answering really Councillor Gray's, I had spoken to the officer about this because I was disappointed as well that the charging points weren't put in place. However, I do think a borough-wide approach is necessary. They don't know what type of machines they want to use, who they're going to get to have the contract, whatever. So, to be honest, a borough-wide approach is probably more sensible at this moment in time, and to make sure that obviously we don't end up with two orphan charging points in Cranley and Queensway. So I think a year probably is going to be reasonable in order to make sure that the borough-wide strategy is implemented. So I would support this. Thank you.
Thank you. Councillor Darcy.
I understand the reasoning for it, but it does kind of set a bad example. For example, in the previous one, we required that they put in 2 charging points for that house. Now, I understand that this isn't not putting them in, but I think delaying it in this way does set a bad example. And also, I think that as a sort of, we're only putting 2 in, but there are 16, as I understand it, parking spaces. Is that right?
Officers?
5 and 9, I think. 5 and 11.
Yes, I can count quicker than them. Sorry. 16.
In which case, 2 seems a very small number. I think we should put at least 25% of them should have charging points, and that would be 4. So sorry?
Sorry, I was just saying that that's why you need a borough-wide strategy in order to work out the percentages, to be honest. And also there's a lot more parking spaces. Sorry.
I'm not against having a strategy. I think strategy is a really good idea, and we should definitely have one. And I'm not against necessarily refusing this. What I'm saying is we ought to up the ante, and rather than saying it's okay, you don't have to do it for a year, we should say fine, don't do it for a year, but do 4.
Thank you. Councillor Ellis and then Councillor Reid.
Thank you, Chairman. Actually, much of what I wanted to say has been said, but I do think that this is a really important issue, and Waverley should be seen to take a lead rather than actually delay the implementation of this. However, I also accept the point that a borough-wide approach initiative, yes, thank you, is important as well. So I'm minded, although initially I did very much want to say no, Waverley has agreed this, it should go ahead. I am, in view of what has been suggested, minded to think that perhaps a year's delay is acceptable, but it can't be any longer than a year. Thank you.
Thank you. Councillor Reid.
I was rather confused by, on page 23, the proposed variation to condition 5, however, that's the paragraph which is almost the penultimate one, says that with the underground cabling and infrastructure implemented at the point of initial development. Now, I read that as it has been done underground. Could someone please explain that? And then I'd like to finish what I was going to say, please.
Sorry, you're on page 32. You said 23. You confused me. I was back in the other application. Officers, would you like to comment?
Sorry, Councillor Reid, would you mind just repeating the question?
Page 33, apologies for first, it says that the proposed variation seeks to implement the electric vehicle charging points in 2 stages, with the underground cabling and infrastructure implemented at the point of initial development. Has that been done then?
I don't think the parking spaces have been constructed yet, so presumably...
I was very surprised to find that they have been made.
Local knowledge, okay.
Yes,
yeah.
this is my ward. They have been made. It's a beautiful site. It's a pleasure to go there, compared with how it was before, when it was churned and covered with vehicle tyre marks and crowded with parking all over the grass. It was unsuitable for any emergency vehicle or an ordinary vehicle to go through. So we don't know that. And I will reiterate the point that Councillor Ellis made, that it is the responsibility, our responsibility, all of us here and at Waverley, to be responsible to take a lead and set the standards and principles for the electric charging points for vehicles. And not to be seen to be adhering to our own policies is setting a dangerous precedent, I think. That's the first point. It was in the local plan. First stage of the local plan has taken more than 10 years to come, and here we are, even now, thinking we're going to delay this for another year. We shouldn't be giving ourselves permission to vary what we have said and put in place as a policy. We were told even this morning by government that they were going to reduce emissions. We have to set the example. I can see on the plan, if you look on the plan now, there is a brand new path leading right through the upper area that we see, or the northern part of the green swathe, and paths leading to the properties which are outlined in brown, which are multi-occupancy. They are flats, and then the houses to the south are all family houses from what I can see. So there's a great need to have these parking spaces. And because people haven't approached the council to say they need them, it doesn't mean to say we should not provide them. I think it's really important. If we are not going to implement this and people do buy electric cars, there's a great danger of them getting extension needs right across public areas, paths, parking spaces, etc. So I'm disappointed, as the parish council was with their report, Cranley Parish Council. I don't agree that they should be put anywhere else in the village. I think they should be here, and we should set an example that all developers in the future could follow and should follow. It's very important, and I thank you for whatever you've done in the past to make these parking spaces on behalf of the residents in Cranley East, because it has been a very dangerous situation for congestion, and the site now is, you can't compare it with how it was before. It is a pleasure to walk there. Thank you.
Councillor Reid, with your local knowledge, are the parking spaces being used?
They are being used, yes. The only problem when I talk to residents there, people in the houses to the south here are, I think one particular chap has a business. He has 2 vans that he wants to park, plus a caravanette, which is, not really suitable
So if they're being used,
spaces.
we're already in breach of this condition, aren't we?
Well, this is my point. I wanted
because
to know
the condition said the parking spaces shouldn't have been used until the charging points are in.
I was most surprised to find that.
Just to clarify, the application is made under section 73A, which which is the section relating to retrospective applications. So, yes, it is being retrospectively made. The
Waverley is currently in breach of this condition.
I believe so. That's my
Right,
understanding.
fine.
Yeah.
Thank you.
Yeah.
We're doing well tonight, aren't we? Right. Sorry, does anybody else wish to comment on it? Yeah, Councillor Darcy.
Just a question, really. When it says that they can be installed, whose responsibility would it be and who would pay for it if we grant this, and whose responsibility would it have been and who would have paid for it if we didn't grant it and it had gone ahead as it should have?
Waverley Borough Council and Waverley Borough Council, I would say.
Is that right?
Yeah.
Okay.
So thank you, Chairman. Just one more point on that comment, Councillor Darcy. There, from my understanding, from this sort of borough-wide approach that we're now taking, is in association with a national supplier who was called Charge Points, now Ngenie. I'm reliably informed, and the agreement with that is that we provide the land, and the company then installs the equipment, and then there's a sort of a profit share between the council as landowner and the provider. So if that answers the question any further. Thank you, Chair.
Councillor Reid, do you wish to come back?
I was amazed to see the transformation after this work's been done. I just couldn't believe that the electric charging points had not been installed. And speaking to other residents of the flats on the northern side, they tell me that this was completed months ago.
Thank you. Councillor Seaborn.
Thank you, Chairman. A question to officers relating to the ability to add charging points at a later date. So we're focusing on two. Councillor Darcy makes an excellent point that we're moving towards electric cars. It may well be in 5 years' time that 50% of the cars here are actually going to be electric, and is just putting the cabling in going to be enough to enable upgrading at a later date, which I think would satisfy Councillor Darcy's requirement? Because I think if we put in 2 spaces now, I'm not sure how many of them would actually be used, but equally things are going to progress at a rate of knots over the next few years, and let's hope in 10 years' time all of the spaces should have cabling. So if the cabling's in, is it going to be easy to upgrade in places that we're not at the moment targeting charging points? Thank you.
Officers, do any of you feel qualified to answer that question?
Chair, that is quite a technical point. I personally don't know the answer. It may be that the housing team would be able to advise you on that. I would imagine if the cabling is in place, then you could add further points. But as I say, it's beyond my knowledge.
Councillor Reid.
No one has answered my question. Is the cabling in? If it's in, surely it can't be too much trouble to put those points in. And could someone point out where they're going to be, please, on the plan?
Councillor Rivers, we're actually still conducting the Eastern meeting, so if you'd like to wait in the... you're perfectly willing to join us and listen, but you unfortunately you can't join in, but thank you. We're still conducting the Eastern meeting, so but feel free to sit down and join us if you'd like. Members, can I suggest, we seem to have an awful lot of unknowns and known unknowns and unknown knowns here. Can I suggest that we defer this application and that you come back with the information that, I mean, we don't know whether these cables are in. Is our housing department aware that they are in breach of the planning permission to construct these and use these parking spaces? Is it possible to upgrade at a later date? There's so many questions. Yes, go on.
I'll just make an observation, really. The condition, I think both the original one and the proposed, says at least 2 of the available parking spaces. So I would take from that the setup has the ability to provide more, because that's a minimum requirement rather than a maximum or a specific
But
number
we
that they
don't
have
know,
to provide.
do we? You're assuming there, or presuming. Beth, sorry.
It's a presumption. And I would also just like to say that I'm not necessarily sure whether the existence or non-existence of the underground cabling is highly relevant. We are imposing a new condition which they will have to comply with. I think it's as simple as that. If the revised condition is acceptable to you, then I think you should go ahead and determine the application.
Who's going to smack housing's wrist then? Thank you, Beth. Councillor Gray, you wish to come back?
I was just going to say that I would then propose a deferral. I mean, I understand the issues, but I think where it's one of our applications, we should have clarity. I don't see it's a particular problem. We have to reach a compromise, and if we're to approve this as it stands, then I think we need some answers to the question. So I would propose we defer it.
I agree, and I'm worried that if we don't defer it and you members decide to refuse this, then our housing department is in breach of the planning. But sorry, Marie, you wish to comment?
Thank you, Chair. I just wanted to make the point that the original application was granted in January this year, and Waverley would have had 3 years to implement that permission, therefore requiring this change to the condition for it to be the rest of it to be implemented within 1 year is quicker than it could have been initially, if that makes sense. But I appreciate they have implemented.
I thought the condition was that the car parking spaces, before they were used, the charging points had to be in. That was how it was explained in the report. And the only way you can occupy a car parking space is to park a car on it, and they're doing that already. So, Councillor Gray, you've proposed that we defer this application. Do we have a seconder? Councillor Dean has had his hand up first. A reason for deferment, I would suggest, is that we do not have sufficient information to determine this application. All those in favour? And just a minute, Beth, do you wish to speak?
Thank you, Chairman. Although I probably understand it, it would be useful for members to articulate the information that they require in order to determine this application. Thank you, Chairman.
Okay, Councillor Gray, would you like to articulate that, and then we'll vote again once you've spoken?
Yes, I think we want to understand that the cabling is actually in there, that the cabling is capable of producing more than 2, and there was some others that I think it's the fact that the cabling is in there, and it's capable, and just confirmation that it's actually already implemented.
And what capacity it has, Councillor Townsend.
Yeah, that's it, to expand.
Sorry, just another thing, sitting here listening to Councillor Gray there, was that, I mean, I have had quite a few conversations with housing about this, so I'm sort of have a bit more probably information about, the overall strategy and how many they're proposing. However, I do think that one of the things that perhaps has to be considered in this is the fact that there are this is some of our tenanted properties, but they're not all tenanted. Obviously, some of them may be privately owned as well. So I think perhaps as well, what would be helpful to know is whether these charging points, what they are being provided for. Are they going to be public charging points, or whether or not they are going to be charging points for tenants? So it would just, if we're going to get more information, could we also clarify that point?
It would be nice to know, but I think we have already approved the charging points, so you're kind of going back on the previous permission, aren't we?
It's not,
but it would be nice to have this
information. It would be nice to have that knowledge as well.
Yes, it would, yes.
Thank you.
Yes, Councillor Gray, you wish to add something?
If I could just come back on that, if they're in public area, there'll be public charging points. Private charging points would actually be on your own land. Councillor Townsend shaking her head, but for instance, you have to make allowances, and probably these will be some of the first people who will use them, are things like doctors, midwives and health services, where electric cars are coming in and they will be visiting some of our areas. So I personally, and that's why they're going to a national provider to basically provide these will be publicly subscribed, not Waverley owned, not Waverley paid for charging points. But I think that's not necessary for us to come back and make an agreement.
Councillor Wojciechowski, you wish to add something?
Yes, thank you, Chairman. Just very quickly, as this is a previous application, it looks like a retrospective one. Would it be prudent that if all the points are satisfied, if this is deferred, that this then can go before delegated powers, as I'm mindful that there's a number of people who come back to this room, mileage, etc., expenses and all the rest of it, and yet more time wasted. So I would, I'm just asking, could it be done under delegated powers if all of the conditions are satisfied? I'm asking the committee, not one individual. Thank you.
I think because Waverley is the applicant, it has to come before committee. Am I right, Beth? Yes.
Yeah. Chairman, I can appreciate that, but I think it needs to be said.
Thank you. So going back, we have a deferral proposed by Councillor Gray, seconded by Councillor Danis, for defer this application for further information, which has been outlined. All those in favour of the deferral?
That's unanimous, Chairman.
Thank you. Thank you, councillors, and safe journey home.